Great. Hi, everyone. I'm Kim Straker, and I want to welcome you to our HR Forum event today, which is a New York-based discussion on two hot topics: compliance with the HERO Act and religious accommodations, excuse me, in response to vaccine mandates. I'd like to introduce you to my two colleagues, Daniel Small and Ashley Ehrman, who will be leading our discussion today. I'll be moderating. We have a PowerPoint that we've prepared to help you follow along during our discussion. We'll be emailing you a copy of the PowerPoint after our event. Daniel will kick it off today by providing you with updates on the HERO Act and ensuring that you know how to comply. He'll address the latest and greatest on exposure prevention plans and implementation of workplace safety committees. If you have questions during his presentation, please put them in the chat box. I'll monitor that and we will address your questions at the end of his presentation. Next, Ashley will provide you with practical guidance on how to question the sincerity of an employee's religious-based objection to a vaccine mandate, and also how to navigate the undue hardship analysis. At the end of her slides, Ashley has prepared hypothetical responses to the three main questions on a religious accommodation request form. I'll be asking her questions about the cooperative dialogue process, undue hardship, and documentation. My questions will be similar to those that we've been asked by clients recently who have had to undergo the religious accommodation process. We thought it would be helpful to share these questions with you and answers. If you have additional questions, please put them in the chat box. We will try to answer your questions during our designated hour, but we have also set aside additional time for questions in separate breakout rooms that you can opt into at the end of our presentation. If you're unable to join us in the breakout room, you can, of course, feel free to reach out to either myself, Daniel, or Ashley at any time by email or phone with your questions. Also, we wanted to let you know that we're recording this event so that we can send the recording out to those clients who aren't able to attend today. I'll be announcing the CLE code later for those of you who want CLE credit. And with that, I will turn it over to Daniel now.
All right, Kim, thank you very much. All right, welcome everyone. Thank you for joining us. As Kim said, I'll be speaking about the New York HERO Act, which is a topic near and dear to my heart, and certainly has been on the top of every New York employer's minds over the past few months, and certainly ever increasingly over the past few weeks. We've been receiving a lot of questions, so what I'd like to do is go through the various compliance points, both those that have already technically passed, those that are currently in place, to help everyone understand sort of different what could or could not remain in effect based on updates that we might be seeing even later this week and beginning of next week as well. So there's a lot of moving parts. It's lend itself to a lot of confusion from what I've seen, and hopefully we'll try to clarify some of that confusion, give you the tools that you need to help comply with the law. So to start things off on the next slide, we some basic background here. This law was signed into this act was signed into law back on May 5th, 2021. Clearly, this act was this legislation was drafted in response to the coronavirus. It's not limited, however, to COVID-19. So I want to make that point clear. Right now, the only airborne infectious disease that's relevant, clearly, thankfully, is COVID. But this law is not going to go away when, hopefully, one day soon, COVID may go away, or certainly the more dramatic impacts on the workforce hopefully will go away. But this will become relevant if there is another airborne infectious disease that comes and has sort of similar pandemic-like effects on the U.S. workforces, or New York workforces, I should say. So do bear that in mind. But certainly for right now, COVID is the focus. So this law was signed, more than a year after COVID initially wreaked havoc on in the New York area on May 5th, 2021. There was some pushback at the time that the legislation was being considered. by the business community and some amendments. And when then Governor Cuomo signed the law into effect on May 5th, he promised there would be some amendments forthcoming. And true to his word, those amendments were considered by both the state and the state legislature, and eventually signed into effect by Governor Cuomo. We'll talk about some of those amendments in terms of where they're relevant later on at various points in the presentation. The idea, as I said before, of the law was to combat the spread of airborne infectious diseases in the workplace by requiring various mitigation measures to be put into place. A lot of them, if you're familiar with it, or if you're not familiar with it, they will certainly sound familiar based on the previously required COVID-specific mitigation measures that New York had in place up until late spring 2021. The HERO Act applies to all private employers. There's regardless of size, regardless of employee count threshold. It is limited to New York employees in terms of its effect, but there's no limitation in terms of which private employers it applies to. In terms of the definition of employee, unlike other statutes in the employment space in New York or otherwise, the definition of employee here is broadly defined. It includes independent contractors, as you see here, part-time domestic workers, home health and personal care workers, seasonal workers, and in the frequently asked questions that the Department of Labor put out, they make clear here that the goal was that it was not going to be limited to traditionally defined employees, but it would be workers beyond that more traditional definition. So that is, in terms of the general background, in terms of the relevance and size and scope of the Act's reach. The next slide, we'll start understanding a little bit more about what it required. So step one is that the HERO Act required the New York State Department of Labor to publish various model safety protocols. You'll probably hear me refer throughout the presentation between safety protocols versus safety plans. They're one and the same, used interchangeably. So the DOL had to promulgate these model safety plans, protocols for employers to adopt or to use as a guide in creating a safety plan. The law required that the DOL put out both general, like a generic standard, as well as industry-specific standards. We'll see shortly what exactly those looked like when they came about. So that was the requirement that was placed on the Department of Labor. In terms of employers' requirements, the Act required employers to do one of two things with respect to these plans. Number one, to either adopt the DOL-issued protocol that is either relevant to their industry or a generic one if there's none, or to establish their own safety protocol by ensuring that it lines up with any emergency regulations the DOL put out. But they would, in that case, also have to solicit employee participation in the development of the plan. I will say that, in my experience, the vast majority of clients that I've worked with on this have opted for the first option in terms of adopting the DOL's version of the protocol, but not to avoid that issue of soliciting employee participation. So again, there is that other option, establishing an alternative plan, but the vast majority of clients have opted for that first option. The protocol or the plan that the DOL would put out and that employers would have to adopt would address and have to address a variety of topics, many of which, again, are very familiar from the COVID requirements that were in place in New York State for businesses, including employee health screenings, face coverings, other PPE, social distancing requirements, and cleaning and disinfecting protocols. Again, those are very familiar topics to those navigating New York business workplaces, again, up until the late spring when these were requirement in the workplace. The next slide, you start understanding what the DOL actually put forth. So again, there were industry-specific protocols they put forth, as well as a generic model protocol. The industry-specific protocols are those listed out in front of you. Again, an employer is technically supposed to choose the one that is most relevant to their industry. Personally, in my review of them, I had not seen that there were major distinctions between them. And there's always the generic one available. In frequently asked questions that the DOL put forth at a later date, they made clear that for office-based environments, that the generic one is the appropriate one to use. But again, if there is an industry, if your business falls into one of these industries, better to use one of those more specific versions. There's a link included in the slides where you can find all the relevant templates, as well as further guidance from the DOL and general updates that the DOL puts forth on their website. Okay, on the next slide, we start digging in a little bit more as to which requirements came into effect at which point. So I guess before going into some of the details here, I'd like to frame this as the initial requirements that were put forth under the HERO Act were for an employer to adopt the plan, like we just spoke about, either adopt or create their own plan. And what we'll see in a second is to distribute and notify their employees of the plan, but not necessarily to implement the plan. Under the HERO Act, there's a trigger to have to actually activate the various mitigation measures under the plan. The first step was just to have a plan in place and notify your employees of it as appropriately, which we'll discuss in a second, not to actually activate the plan just yet. So as of September 4th, employers were required to distribute the plan to their current employees, provide the plan to any new employees hired thereafter after that initial date of distribution, to provide the protocol to all employees after a business reopens. So if a business is shut down based on an airborne infectious disease, spreading throughout the workplace, and we're required to shut down based on government protocols or the like, then they would have to, when they reopen, they would have to issue it again to all employees. Employers also have to post the plan in a visible and prominent location in the workplace. No guidance has been given as to exactly what that means, but we typically advise that would be like an employee break room, for example, where you might have other required postings placed. And then finally, separately, the employers are required to include the safety plan in an employee handbook if the employer has a handbook, to include it there. By doing so, you'd presumably be able to satisfy your requirement of providing it to any new employees. If they receive the handbook upon hire, the plan's included in there, that would satisfy the requirement for any new employees, again, hired after the date of the initial distribution to all current employees. So these are all the distribution and notice requirements that the HERO Act has. Again, as of September 4th, there was no requirement to actually activate and put into place the various mitigation measures in the safety plan, just to have it in the back pocket, like I like to call it. On the next slide, however, we'll see that things changed on September 6th, because on September 6th, the Commissioner of Health, due to the surging cases based on the Delta variant, the New York Commissioner of Health designated COVID as, quote, highly contagious under the HERO Act, which was sort of lingo from the act itself, to trigger compliance measures needing to be activated. So as of September 6th, which was actually Labor Day, later that evening is when the governor announced that this designation was put into place. And what it did is that, again, employers not only had to ensure that they already distributed, posted the plan, and established the plan, certainly, but now they actually had to implement and activate the requirements under the plan. And what did that include? So that included various requirements like a daily health screening, masking and physical distancing, and also a training requirement. I'm going to get into each of those in just a second. But what I wanted to note is that at first, the implementation, actually, no, let's talk about each of those first. So with respect to masking, when this announcement first came out, there was no, the requirement was that employees would have to mask if proper distancing could not be maintained. So if desks weren't separated, or someone was in their own office, and desks or cubicles couldn't be separated, by the appropriate distance, 6 feet or what have you, then masking would be required, irrespective of vaccination status. That led to a lot of confusion initially. Ultimately, the DOL issued on September 24th revised safety plans, and what they included was an option for employers that can ensure that all employees on premises, that if all individuals on premises were in fact fully vaccinated, then masking would not be required. But the implication was if you could not ensure that, and again, it's not all individuals, so that would include visitors as well, or guests, clients, etc., then masking would still be required even under the more lenient variation of the safety plans that were put forth on September 24th. That's how the masking played out eventually, and that's where we stand right now in terms of the masking. The daily health screening is in effect as well. That would be similar. There's no clear guidance on what that has to look like, but certainly adopting the daily health screening that was previously required back in the spring of 2021 under the New York COVID-specific requirements, that, asking the specific questions about symptoms, any recent exposure, et cetera, that would certainly satisfy the obligation here. And then there was a third piece, which was a training, or a quote, verbal review, as it's called under the Act. Now, their employers were required to provide, again, independent of the distribution requirement we spoke about earlier, which was to distribute the plan to all employees, providing them a copy of it, maybe a link on the internet site to a copy of the plan that could satisfy it as well. But to ensure that it was distributed to all employees, there was a separate requirement under the Act. Once the mitigation measures were activated by this designation we spoke about, that they also would have to sit down or sit down, not necessarily sit down, but conduct a verbal review with each employee. So merely sending the plan out via email would not satisfy the strict requirement of a verbal review, but there are potential options in terms of how to satisfy that verbal review per the DOL's frequently asked questions, including providing a audio conference call, a video conference call to discuss the employees with. We've even seen clients maybe record talking points that would, the substance of which would satisfy the requirements of the verbal review under the Act. And those are various ways that an employer could satisfy this training. There are specific topics that are listed out in the safety plan that have to be included in the verbal training. Many of those are covered presumably covered in an employer's basic COVID return to workplace training, it to the extent they have one. But there are some specific requirements like anti-retaliation provisions that must be covered as well. When this activation of these various mitigation measures I mentioned before, September 6th was when it was put into effect, when this designation was announced. Initially, it said it only was going to last. It was going to last through September 30th, unless the Commissioner of Health extended that designation. There was some confusion because they didn't do it as of September 30th. They did it a few days later and then tried to backdate it to make it look like they did. But eventually, they extended that designation through October 31st, which is where we stand right now. Obviously, as you might recognize, October 31st is this coming Sunday. So presumably, we'll get an update whether the designation has extended an additional month, or if it's going to expire. If it expires, that means these masking requirements, daily health screening requirements, et cetera, would no longer be required under the HERO Act. So that is still, we don't know if that is going to continue into November. With no basis, my gut tells me that due to the declining rates of transmission in New York, my guess is they're not going to extend the designation. But again, there's been no reporting, there's been no announcements made by the Department of Health. So we will continue to monitor that and put out client alerts, et cetera, to advise when we know more. But again, as of right now, we do not know. So I don't want anyone walking out saying that we said the designation for sure will expire. We don't know that. But again, my personal guess, it seems that it's most likely to expire due to the thankfully declining rates of transmission at this time. Okay. Turning to the next slide, I want to talk about quickly about what employee rights, the rights employees have under the Act. So their employees are entitled to report violations of the safety plan to any state, local, or federal government entity. They are allowed to report concerns related to the disease in the workplace to the employer or any government entity. And they're also, importantly, allowed to refuse to work if the employee, and I put in quotes here to emphasize sort of the various caveats, if the employee reasonably believes in good faith that the workplace exposes him or her or other workers or the public to a, quote, unreasonable risk of exposure. So there's sort of a lot of barriers there for an employee to properly refuse to work under the Act, but there is this option if the employer is really just not taking any of the necessary requirements under the Act. And again, not just doing that, but also that failure to take those, to meet those requirements is leading to an unreasonable risk of exposure in the workplace to employees. If employees exercise these rights, employers are prohibited from threatening, retaliating against, or taking adverse action against the employee. So do bear that in mind. Again, a typical anti-retaliation provision for an employment and safety-related laws in New York. And then One more topic on this particular part of the HERO Act. This is the sort of section 1 of the HERO Act, the safety plan. So on the next slide, we'll just see some of the penalties that are in place for violations. If the New York State Department of Labor, if they sort of conduct an investigation and determine that the employer has failed to comply with the requirements, they can assess certain penalties, including a 50-day per day penalty for failing to adopt or establish a plan, which again is pretty minimal, but has now accrued if one has failed to have done that dating back to August. And there's also a $1,000 to $10,000 potential penalty for failing to comply with the actual plan. So one is for failing to establish a plan, and one is for failing to comply with the plan. The Act does also provide a private right of cause of action for employees, so they can sue an employer for injunctive relief if an employer fails to comply with the Act itself. The HERO Act also allows for an awards of attorney's fees and costs to prevailing plaintiffs. But importantly, and this is one of the amendments that I mentioned earlier that Governor Cuomo signed into effect, which was coming from the business community when they pushed back. This was one of the more, I guess, somewhat beneficial parts of the amendments, was that it provided a notice and cure period for 30 days. So an employee could not sue until they gave an employer notice that they felt that there was a violation of the Act, and an opportunity for the employer a reasonable amount of time for the employer to cure that violation. And then finally, another employer-friendly part of the amendment was that an employer can be awarded attorney's fees and costs if it's required to defend against a lawsuit that is deemed by a court to be frivolous. So if an employee is just frivolously filing lawsuits, an employer can demonstrate that, and a court finds as such, then an employer would be entitled to recoup their attorney's fees that they had to spend on defending such a lawsuit. Okay, that is all that's all section 1 of the HERO Act. That's all really anyone's been talking about until now. The safety plans, how to properly implement them, adopt them, etc., and the various moving parts therein. There's one in just the last little bit of my time here. What I want to talk about is a topic that's becoming more to the forefront, which is the workplace safety committees. So on the next slide, we see that beginning November 1st, which is also now when we first were advising, it seemed a ways off. Now it's certainly right around the corner. But beginning November 1st, employers with 10 or more employees, so this section of the HERO Act, just want to stop there, there is an employee headcount that is relevant, unlike the other provision of the Act. It was irrespective of how many employees the employer had. Here, as long as the employer has 10 or more employees, they must permit the formation of joint labor management workplace safety committees, which sort of has a little bit of a union feel to it, a little bit. Note that the law says that employers must permit the formation of these. They do not have to create them on their own, and there's no notice requirement here. So it's not like the employers have to notify employees of their ability to come forth with the initiative to create one of these. Employees would have to think of it on their own, be notified of it on their own. Employers do not have to notify employees of it. But they do have to permit them. So if employees do come forward requesting the creation of such a committee, employers do have to allow that to come about. Now, the committees, under the law, the committee must be comprised of at least 2/3 of non-supervisory employees, and they must be selected by non-supervisory employees. So there will be employer-designated representatives, or there could be, but there's a limit on how many there can be, and there has to be at least 2/3 of non-supervisory employees selected by non-supervisory employees. So clearly a non-management push in terms of the majority of the composition of employees on this committee. What is the scope and jurisdiction for these committees? They're allowed to raise concerns regarding workplace health and safety issues, review employer workplace safety policies, participate in government site visits should any come about, and they must be allowed to meet at least once a quarter and attend certain trainings on the clock, so on paid time to attend these trainings. The amendments that I mentioned earlier that Governor Cuomo signed into effect limited or gave some clarity that the committee meetings are limited to once a quarter for the year, up to 2 hours, and that the trainings that employees are allowed to attend, that employers must permit on the clock, can be for no more than 4 hours. Presumably that's referring to when they're first elected to the committee or appointed to the committee, but there's been, again, very little guidance on this. To the next point, the DOL has promised in their most recent publications they put out that they will issue guidelines for this section 2, the Workplace Safety Committee portion of the HERO Act, before November 1st, the effective date. I just checked right before we came on. There still have been no guidelines put out by the DOL giving anyone some guidance here. There's been very little discussion of this particular portion of the Act, partly presumably because employers, there's only so much they can do. They're not required to create these, they're required to permit them. So there's only so much employers are going to do on the front end here. And then number two, the DOL is doing what they're playing catch up a lot in this. So hopefully they'll come out with something before the effective date. It wouldn't be the first time if they came out with something after the effective date. So we might have to sort of navigate this like we did with the Section 1 before they put out guidance, even though it was post-effective date, and sort of navigate it the best we can. That is, in sum, where we stand right now with the HERO Act. So again, I would just say quickly, there are various mitigation measures that need to be put into place right now through at least October 31st, pending either extension of the COVID designation from the Commissioner of Health. If they are not put into place, if the designation is not extended, then those mitigation measures would not need to be implemented. But again, there was all those preliminary compliance requirements that should have been complied with in advance in terms of adopting a plan, distributing the plan, posting the plan, including an employee handbook, etc. That's all for Section 1. Upcoming November 1st, effective date for Section 2 of the HERO Act, permitting the creation of these joint labor management workplace safety committees. With that, I will turn it to Kim to see if she has any questions from the queue.
Great, thanks, Daniel. Just a few questions to ask you. So the first one that came up was, if a company has negotiated safety protocols with a union that are actually a higher standard than what the HERO Act is requiring, does that mean that they then are in compliance with the HERO Act?
So per the language of the statute, if they have bargained and come up with a plan that meets, and if it does in fact meet and or exceed the standards required under the HERO Act, then yes, that would be sufficient. Okay,
great. And if a company that through that negotiation of the CBA, if a company does violate one of the standards, would penalties apply, even though they're higher standards? Or are we not sure about that?
Probably would have to take a look. My sense was the penalties would apply because that would be the version of the plan that they've adopted. Again, they're required to either adopt the DOL plan or create a alternative plan. This would be an alternative plan, and the penalties would seem to apply irrespective, but I could see the nuance there, so that we might have to sort of revisit that.
Okay, great. And then one last question. Is a company required to implement the safety plan if all of its employees are still working remotely?
That's a good question. We have seen that a few times as well. So because the act is geared towards preventing the spread of COVID in this case in the workplace, if there are no employees in the workplace, then technically there would be no need to put these mitigation measures into effect. Again, all the other compliance points might need to put into effect. But one caveat on that, because I've had this as well with some clients, is sometimes clients say, "Oh, we haven't had our return to work yet." But if you have some employees, like administrative employees or IT personnel, who are in the workplace during this period of time where COVID is designated as highly contagious, triggering the mitigation compliance points under the Act, and there are people there, you just haven't had your official reopening, the Act doesn't really distinguish between an official reopening or soft reopening or any of that nature. If there are employees in the workplace, then the goal is to prevent the spread of the airborne infectious disease in the workplace. So those various points would need to be required. Now, if you have that, only those who are coming to the workplace would need to be, for example, screened for symptoms under the Act, because they're the ones who are at the work site. But do be mindful of that distinction between an official reopening. But yeah, if there are no employees at the work site, then those mitigation measures, there would be no point in having those mitigation measures in effect.
Okay, great. Just one last question. If a company has employees that have been granted exemptions to a vaccine mandate does that mean that then all of the employees have to wear masks, because then not everyone is vaccinated in the workplace?
So we've seen this question. So my read, and I think this is consistent with the purpose of the Act, but also the language of the safety plan, and I think this is the general consensus, is that, again, so take a step back for a second to explain where this question is coming from. We mentioned before that the revised safety plan that the Department of Labor put out provided a leniency that if all individuals on premises are fully vaccinated, then masking would not be required at that work site on those premises. So the question is asking, what if someone has a vaccine exemption, a vaccine mandate exemption? They're based on either religious or medical requirements. Does that individual's inability to get the vaccine not require everyone to be masked in the workplace? And my answer to that is yes. Technically, that is required because, again, the language says all individuals on premises, which, again, would be more than just employees, according to the DOL even. But someone who is unvaccinated in the workplace, even if it's for a legitimate purpose and required under law, under other laws, that won't prevent the spread of the airborne infectious disease in the workplace. That person could still be carrying the disease, having not been vaccinated. So it would not fit into that exemption from my read of it. I could see why that could be a little bit difficult, and sometimes there could be some creative solutions to get around that. But technically, it would seem that is, in fact, going to be required for all employees to mask if there's one individual there who has a vaccine exemption.
Okay, great. Thanks, Daniel. Just keeping an eye on the time, we're going to move along to our next section on religious accommodations during the pandemic, and we'll turn it over to Ashley.
Thank you, Kim and Daniel. That was great. Hi, everyone. I'm going to kick off our discussion on religious accommodations today. Actually, just this past Monday, the EEOC updated and expanded its technical assistance and added updated guidance on religious objections. So today we're going to go through that information in depth and walk through a hypothetical request at the end of our slides to provide some practical aid guidance as well. So starting with some background, although the numbers appear to be better than months prior and thankfully last year, the risks associated with COVID-19 are still present. And this means that many employers are busy developing plans to allow employees to safely return to work. And as part of these plans, employers may allow and may require employees to be fully vaccinated. And this is really why we are currently experiencing an increase in mandatory vaccination policies, and with that comes the religious exemption requests. But this brings up an important question. What about those employees who can't be vaccinated due to sincerely held religious beliefs? Do they need to comply with this mandatory vaccination policy as well? And the answer is no. There's actually good news for these employees because they have protection under the law in New York. So in New York, the New York State Human Rights Law allows employees to request a reasonable accommodation for sincerely held religious beliefs. So that's kind of the standard we're going to be diving into deeper today. But that means we have to first discuss how is religion defined, what constitutes a sincerely held religious belief, when can an employer question sincerity, and when is a reasonable accommodation necessary. So on the next slide, we're going to start with what is the definition of religion. So as we just stated, the law allows employees to seek a reasonable accommodation for sincerely held religious beliefs. But what does religion mean? It's not as clear as we may think. So the term religion is broadly defined, and it's meant that way to include a wider range of beliefs. So according to the EEOC's guidance on this topic, the term religion includes, and I quote, all aspects of religious observance and practice as well as belief. So to break this down a little bit further, religious beliefs include those that are tied to maybe formal, organized religions, as well as those that are new, uncommon, maybe not part of formal religions that we have here in the United States, or maybe those that are only followed by a small number of people. So it's important to remember as you're going through employees' requests that the request should not be automatically denied just because their belief is different than a large majority, or just because their belief doesn't conform with traditional religions that we have here. But it's important to note that religion does not include social, political, or economic theories, as well as medical reasons or personal preferences. These will not be entitled to a reasonable accommodation under the laws in New York. So moving on to the next slide. Now that we've defined religion to include beliefs that are commonly associated with major religions here, as well as those that may be less common or less followed, we can move on to talking about sincerely held religious beliefs. So the law does not require employees to accommodate all beliefs. In fact, the law only requires employers to provide a reasonable accommodation for sincerely held beliefs. And it's the employee's job to state that their religious belief is sincere. So for example, if an employee is seeking a religious accommodation, it's their job to provide the employer with enough information to make sure that the employer is aware of the conflict between their religious beliefs and the employment requirement, which in this context would be vaccination. So employees can state the sincerity of their beliefs and put the employer on notice by completing an exemption request form. This exemption request form will be provided by the employer, and as good practice should include points of contact for the employee to reach out to with any questions. But an ideal response showing sincerity will typically include the specific religious practice or doctrine that the employee follows, as well as an explanation as to how this practice or doctrine prevents them from compliance with the mandatory vaccination requirement. The employee may also include any other additional helpful information that they have to show sincerity. Maybe they have past behaviors that comply. Maybe they've declined past vaccinations, such as the flu vaccine. So that can be included as well. But we know that employees are not always going to present their religious beliefs in this way, and it's very possible that there may be instances where the request form is incomplete or sincerity is questioned. And this is especially true in these times because there's an unprecedented number of religious exemptions being submitted across the state. Religious figures across the country are actually soliciting their services to write letters for employees that they've never met. And there's countless fillable religious exemption templates that are found online where all the employee has to do is just fill in their name and submit it to the employer. So in these situations, employers do have an opportunity to ask further questions. And we'll go through this on the next slide. So as we stated, although employers do have the option to question the sincerity of a religious objection, it's important to proceed with caution. And it's important to fully analyze the situation before rapid firing questions to the employee. And this is really because unreasonable requests for either unnecessary or excessive information that the employee already included opens the door for retaliation and harassment lawsuits, which definitely are not ideal. So deciding whether or not to question the employee about their beliefs is really going to depend on the employee's exemption request and the amount of detail that they included. So it's important to note that this is in a case-by-case basis, but we're going to provide some general guidelines that you can follow as you go through exemptions. So there are some instances where it's safe for the employer to make a further inquiry, which are included here on the slide. So we'll go through them one by one quickly. So first, boilerplate forms. This refers to those fillable exemption request letters that are found by doing a quick Google search. So normally these letters outline multiple religious objections to the vaccine, and normally just include a line for the employee to put their name on. So because these forms are not in the employee's own words, the sincerity of their belief that they're stating in this template is questioned. So it's safe for the employer in this situation to ask follow-up questions. The second one is identical submissions. So as you're going through requests, if you start to notice that a handful of employees are submitting identical requests with the same word-for-word explanation, in this case, it's safe to say that the sincerity is once again questioned because, like before, the request is not in the employee's own words, it's being circulated. So this is another instance where the employers may follow up and ask additional information. And then third is sudden shifts in explanation, which is actually quite common. So this comes up where the employee starts including information that has nothing to do with religion, and then they suddenly shift to include specific religious doctrines. So for example, the employee may write a paragraph stating that the vaccine is not safe, or maybe that there's insufficient research or any other explanation. And then they conclude by mentioning that the vaccine uses fetal cells, and because there's fetal cells, it violates their religious objections to abortion. Well, in this situation, the employee is including both non-religious and religious reasons. So when there is this shift, the employer may ask further questions to essentially determine which reason is predominant. So is the employee's reason really an objection, a religious objection, or is it really that the vaccine is unsafe in their opinion, which would not be entitled to protection and a reasonable accommodation. And then finally, we have vague or incomplete requests. So if an employee submits a request that lacks a religious practice or maybe a doctrine, or just doesn't include an explanation, it's just otherwise insufficient, you are able to follow up and gather more information. And in this situation, doing so won't be considered unreasonable or unnecessary. So you don't need to risk lawsuits because the information is lacking. So you don't need to worry about that. And then on the next slide, we are going to get a little further into this. So as you are going through requests and determine that follow-up on the employee's belief is needed, the inquiry should take the form of an interactive or cooperative dialogue. So essentially what this means is that you will have a conversation with the employee. You'll ask the employee questions about their religious beliefs in order to gather more information or just to better understand their religious belief in general. And when you start engaging in this process, we normally say that open-ended questions are more helpful. And this is really because when you ask an employee open-ended questions, you're allowing them to tell you information about their belief without limitation. And we have a slide coming up on specific questions you may ask, but some general areas you may want to inquire into will include what the employee knows about the vaccine. And this is especially true when the employee states both a religious and a non-religious reason, because asking this question will help you determine whether the employee's objection is maybe based more on political, medical, personal reasons rather than a religious belief. Some other areas include the specific religious doctrines or practices, as well as whether the employee has been vaccinated in the past. And if they have, it's helpful to know why is the COVID vaccine different than past vaccinations. And once again, if this is helpful because it provides more information about the employee's sincerely held religious beliefs. So for example, if the employee received the flu vaccine and can't religiously explain why the COVID-19 vaccine is different, you may determine that the request is not supported by a sincerely held religious belief. And then the next slide includes all of the questions that you may ask the employee. So we'll run through these. So you can ask them, what is the name of your religion, if any? And we say if any because if they say that they don't belong to one particular religion, maybe they just follow their own religion. If they can support this, that's permissible. The next one is, what is the nature of your beliefs, practices, observance? When did you first become a member, or when did you first begin to embrace these beliefs? How do the company's policies and or procedures conflict with your beliefs? And then you can also say, I'm respectful of whatever you believe, but I need to better understand in order to consider your requests. So what is it about your religious beliefs or practices that prevent you from getting vaccinated? And we include this language as an example because you want to make sure that you are approaching it in the sense that you're not doubting the employee's beliefs and you're not doubting their religion, but you just need to get more information. Other questions include, have you ever received any vaccines before, and what is the difference, and whether or not the employee has any additional information. So the next slide goes into the next piece, which is undue hardship. So if you ask these questions and you determine that the employee has a sincerely held religious belief that actually does prevent vaccination, a reasonable accommodation must be made. And this is true unless doing so would cause an undue hardship. So what does undue hardship mean? Well, undue hardship refers to anything having more than a de minimis cost or burden on the employer. To define that a little bit better, essentially anything that causes a significant difficulty, expense, will be considered an undue hardship on the employer. And we'll go through this. as well in the hypothetical later. So as stated on the slide, there are some things that you want to consider when determining whether a suggested accommodation will cause an undue hardship. So the first possibility is remote work, and this is extremely common. And we will discuss remote work further in detail, but it's important for now to note that if your company allows remote work for other employees in the same position, remote work should also be an option for the employee refusing vaccination as well. But once again, we will get into this more. Secondly, the frequency of in-person meetings or gatherings is also very important to consider. So if the employee's job requires infrequent in-person meetings or face-to-face interaction, or doesn't really need to be performed indoors, you may need to implement frequent testing, mask wearing, social distancing, or other protective requirements as well as a reasonable accommodation. But this will really depend on the employee's duties and the nature of the workplace as well. The third is the availability of alternative positions. So it's also worth considering whether there are other vacant positions for which the employee is qualified for without being vaccinated. So maybe there are other positions that are in a different shift that are less busy. Maybe there's less employees during that time. A reasonable accommodation may consist of transferring the employee to that position. But once again, this will largely depend upon the employee's duties as well as the characteristics of the specific workplace. And then finally, the risk posed to others. So it's important to consider whether testing, mask wearing, social distancing, and other measures will be sufficient enough to reduce the risk posed to others. And it's also important to consider whether the size of the workplace allows for social distancing, once again, whether or not the work can be conducted outside. And this will largely depend upon the employees' responsibilities as well as the workplace. So on the next slide, we're going to get into remote work a little bit more, just because it's been so common lately. And this is especially because our lives consisted solely of remote contact for almost a year over the height of COVID-19. So we're used to it and we experienced it. So now many employees are requesting to continue working in this way. And as we briefly mentioned before, remote work may be considered reasonable accommodation. But for these requests, it's important to keep in mind two important questions. And that includes whether other similarly situated employees work remotely. And if the job was remote during the pandemic, why or how is continuing remote work an undue hardship now? So in other words, if one employee works remotely, others in the same position should likely be entitled to the same opportunity. And if the employee declining vaccination worked remotely during the pandemic with little to no issue, it must be explained by the employer why remote work would cause an undue expense or hardship now. If there's no difference between then and now in terms of this difficulty or expense, remote work may be a reasonable accommodation. So that was an overview of the religious accommodation process, including how an employer can question the sincerity of an employee's religious belief, as well as the undue hardship requirement. So now on the next slide, we are going to introduce the step-by-step religious accommodation hypothetical to kind of put this into a practical setting. So this is a hypothetical religious exemption form, which we created. We also created the employees' responses as well. But what you're looking at are typically the three questions that employees are asked when submitting a religious accommodation request. So the first question will typically ask them to specify their religious beliefs, practices, or observances. So here, that's what we did. And then the employee responded by saying that their religion is Christianity. And in accordance with their Christian faith, or their Catholic faith, they do not believe in medical intervention, and that their faith instructs them that God is the ultimate healer and will protect them from disease. So the second question will ask the employee what specific work requirement conflicts with their religious belief, which in this case, their religious belief is no medical intervention. So the employee here responded by saying that the company's mandatory vaccination policy conflicts with their beliefs because vaccination is considered a medical intervention to them. And then finally, the third question will typically ask the employee what specific reasonable accommodation they are requesting in lieu of getting vaccinated or any other employment requirement that's at issue. So here the employee responded by saying that they're requesting to work remotely and that they've done so for the last year and a half. So doing so is not going to impact the quality of their work. And if they're allowed to work remotely, their vaccination status won't pose an issue to other people.
Great, thanks, Ashley. As I mentioned in my intro earlier, I'm now going to ask Ashley some questions relating to this hypo that will help guide you through the cooperative dialogue process and the undue hardship analysis. So, Ashley, after you receive this form here shown with the employee's responses filled out on it, you have some follow-up questions for the employee. Is it better to email the employee your questions or set up a time to talk by phone?
We say that it's better to set up a time to talk by phone if it's possible. And really this is because you want the employee to have an opportunity to speak freely and candidly, rather than having some extended period of time to prepare a written response with the help of other people or maybe a lawyer.
Okay. And during your phone conversation, what are some of the questions that you would ask here to question the sincerity of this employee's religious belief?
I would definitely refer to the questions that are listed on a previous slide, but highlighting some of the important ones here, definitely asking whether or not they've been vaccinated in the past and how the COVID vaccine is different, whether they first began or when they first began to subscribe to these beliefs, as well as just asking them to help me understand why medical intervention conflicts with their religious beliefs, so that way we can go through their request with more information.
Okay. Now this employee is requesting to work remotely, but let's just assume that the employer here can accommodate her exemption from the vaccine requirement by having her social distance, wear a mask, and test weekly. Can the employer then deny the remote work accommodation?
Yes, so you don't need to provide the accommodation preferred by the employee, which in this case would be remote work. So if you find that it's safe to allow the employee to enter into the workplace and abide by social distancing, masking, weekly testing requirements, that will be fine. However, it is important to note that this alternative accommodation will no longer be considered reasonable if, for instance, there's more favorable accommodations provided to other employees, or if this accommodation that the employer chooses forces the employee to suffer maybe a pay decrease or some other loss in benefit.
Okay. And this employee here, as we see, has worked remotely for the last year and a half. So in light of that, can this employer still claim undue hardship now?
Yes, so the employer can still claim undue hardship. For instance, maybe the employee has certain tasks that must be completed in person. And by allowing this employee to be remote, their tasks will then be pushed off onto someone else who's physically in the office. And this would affect efficiency, because the employee in the office would be forced to take on additional tasks, and this would impact their workload as well. But this is just one example. The reason will largely depend upon the nature of the employee's position, as well as the unique circumstances of the workplace. It's also important to note whether or not there's a reason that in-person work is required. If in-person work is required because the employee needs to attend meetings or talk to people in person, then that's something to consider as well.
Okay. Now, would it be considered undue hardship to say that if you allow one employee with a religious conflict to work remotely, then you as the employer will get stuck having to allow so many more who come forward in the future? And that would be too hard financially on the business, like the so-called slippery slope theory.
Yeah, so an employer can't rely on hypothetical hardships. So instead, the employer should rely only on the objective information that they have available at the time they're making the decision. So a mere assumption that many more people in the future with the same religious practice as the person being accommodated may also seek the same remote work accommodation. This alone is not evidence of undue hardship.
Okay. And to prove that there is more than a de minimis cost to employers, what are some examples of reasons that employers can rely upon?
Yeah, so the employer can point to direct monetary costs, and they can also point to the burdens on the employer's business. So for example, courts have found undue hardship where the accommodation diminishes efficiency in other jobs, as we talked about previously, or maybe infringes on other employees' rights or benefits, and importantly, maybe impairs workplace safety or risks spreading COVID-19, or maybe causes coworkers to carry the accommodated employee share of responsibility. So whether the proposed accommodation conflicts with other laws will also be considered as well by the employer.
Okay, great. And if you're going to deny an accommodation, how should this be documented?
So if you're going to deny, then you have to notify the employee in writing. So under the New York City cooperative dialogue requirement, the final written determination must be in writing. Along with this, you should also include a self-serving statement, which will document the cooperative dialogue as well as when the dialogue actually took place as evidence.
And if you cannot accommodate someone, what is an example of, or what are some examples of interim steps that you can take before terminating them?
Sure. In this situation, you can definitely grant unpaid leave. You can continue benefits during unpaid leave. And if you want to give the employee or have the employee sign a separation agreement with a release, you can offer them payout of something that they otherwise would not be entitled to receive. So an example would be like unused accrued personal time off.
Great, thanks. And then a question did come up in the chat box about, here in this hypo regarding medical intervention, you talked about asking questions regarding prior shots, flu shots or prior vaccines they may have received. What about, would you say that it would be fair to ask them if they've ever taken antibiotics or other kinds of prescription medicines? Like, would that constitute medical intervention? Is that a fair
Yes.
question?
Yes, definitely. So those questions can be asked. I would proceed with caution though, just to make sure and make it clear to the employee that you're not asking them for their medical history, and to make sure that you're not asking them for exactly the names of what prescriptions that they've either taken or refused, because that brings a whole bunch of new issues into it. But these questions definitely can be asked, and the answers will provide you with information as to whether or not their sincerely held religious belief is actually sincere.
Great. So I have a few more questions for you that have come in on the chat box, but before I do that, I wanted to announce the CLE code. It is Seyfarth Shaw SS. So SS 8992. So again, SS as in Seyfarth Shaw 8992. So then just a few more questions that have come in. If you determine that the employee does not have a sincerely held religious belief, how would you go about communicating that to the employee?
This would have to be communicated to the employee. It's recommended that this would be in writing. I think it would be up to the individual company as well as the employee as well, whether or not they think that maybe just a letter would be sufficient, or whether a phone call would be better in addition to a letter. I think that this really would depend on the specific circumstance, but in either event, it does need to be communicated to the employee.
Right. Okay. And can a sincerely held religious belief also cover a refusal to submit to weekly COVID testing?
That can, yes, that can be included as well. The employee will just need to include a religious doctrine or practice or something to prove that they have a sincerely held religious belief that prevents weekly COVID testing. I haven't seen it come up much. Normally it's with the vaccine mandates, but it is possible.
Okay, great. I did just get a request in to repeat the CLE code, so I'm just going to repeat that one more time. It's SS as in Seyfarth Shaw, and it is 8992. Then also another question came in about an employee objecting to some of some questions that could be asked, stating that you're inquiring too much into their medical history. But I think, you had said, you do have to tread lightly here because you don't want to inquire too much into medical history, right? I mean, is there anything else you want to add on that?
I think that just reiterating that you can ask them whether or not they've taken medication or prescription medication in the past. But it's either whether you're doing this through writing or on the phone, it's important to emphasize that you are not asking for medical history. You're not asking to speak to their doctors. You're not asking for prescription drug names. You're just asking a yes or no question.
Right. Okay. And I know you've been reviewing religious accommodations lately. Have you ever seen a request come in regarding witchcraft?
Yes, we actually have. So this kind of goes to the point of it's important when you're going through requests, if someone expresses that they have a belief that may not be as common, not to just automatically overlook them. So if someone who does express a witchcraft belief and they support this, that is under the EEOC's guidance, that is a religious belief that would need to be accommodated.
Great. Well, thank you so much. And thank you everyone for attending. I do see that we are over the hour. So if you would like to join us in one of our breakout rooms, please do so. We will be around for 15 minutes to answer any additional questions that you have. So just please opt into one of the breakout rooms. Thank you.